jurisdiction in the case against Mr. Gravas. My name is Judge Bafadhel, and I'm joined by my esteemed colleagues, Judge Sémien and Judge Clark. I'd like to start now with introductions from the prosecution and then to the defense. And then please, when introducing yourself, please set out how you intend to utilize your time in your initial submissions. Thank you.
Your Honours, my name is Madison Winan, and I appear alongside my learned co-counsel, Mr. Jeremy Brown, on behalf of the Office of the Prosecutor. I will plead for 12 minutes and will address the challenge to jurisdiction. My co-counsel, Mr. Brown, will plead for 13 minutes and will address the admissibility challenge and also the Article 28 submissions.
Thank you. If I can turn to the defense now, please.
Madam President, distinguished members of the court, it is an honor to appear before you today. My name is Shane Andrew Magnaye, and I, along with my learned co-counsel, Ms. Eric-Aimé Sémien, respectfully enter our appearances as counsels for the defendant, Mr. Gravas. Regarding the established agenda for today's hearing, this court has allocated 25 minutes to advance our submissions. And with the permission of the court, I will address the first two issues relating to admissibility and jurisdiction for 15 minutes, whereas my co-counsel will assist you on the third issue of criminal responsibility for 10 minutes. We respectfully reserve 5 minutes for a rebuttal if necessary. Thank you.
Thank you very much. Okay, if I can now turn to the prosecution then to begin your submissions.
Your Honours, today I will make submissions on the challenge to jurisdiction made by the defence under Article 19, subparagraph 2A of the Rome Statute. Here we submit that there are reasonable grounds to believe that the case against Mr. Gravas concerning the crime of genocide by way of killing under Article 6A of the statute and by inflicting conditions of life on custodians designed to bring about their physical destruction pursuant to Article 6C of the statute falls within the jurisdiction of the court. We say that the relevant genocidal acts were targeted against the Castilian ethnical group with the intent to destroy the group in part. On this basis, we submit that the case should proceed. As our first submission, we say that territorial, personal, and temporal jurisdiction are present because the case has been referred to the ICC prosecutor by the UN Security Council. Therefore, we will direct the focus of our submissions today towards the court's subject matter jurisdiction. Here, the pretrial chamber must find reasonable grounds to believe that the elements of genocide are satisfied. And these elements are, firstly, that the victims were from a protected group. Secondly, that an act listed in Article 6A through to E was committed. Thirdly, that there was an intent to destroy the protected group in whole or in part. And finally, the contextual element, which requires a manifest pattern of similar conduct directed against the group. Turning firstly to the identification of the group, our submissions today are that Castilians were targeted in their capacity as an ethnical group. The first charge of the indictment concerns genocide by killing under Article 6A. In respect of this charge, we refer to the reported total of 200 Castilian men killed in Luz and Luzari, and additionally to the 86 victims who were shot in the head between July and October 2019. We suggest that shooting in the head is a particularly egregious form of killing, which we say goes towards Mr. Gravas's genocidal intent, which I will deal with later in my submissions. There also is the charge of inflicting conditions of life on Castilians designed to bring about their physical destruction, which is under Article 6C of the statute. Here we submit that the specific conditions inflicted were, firstly, destruction of the means of survival for members of the target group. And here we're referring to the forced closure of all businesses in Luz and Cecile between the 11th of July and 30th of August 2019, and also the blockade of all routes into and out of Castilla. The ICTR at paragraph 691 in Buchanan and paragraph 517 in Starkich placed the emphasis on the causation of a slow death when interpreting the equivalent provision in the Genocide Convention. Here we submit that Hanatun forces indeed facilitated a slow and debilitating death for Castilians, as we know that famine resulted from the blockades throughout the region. The second condition that we submit was inflicted was the forcible displacement of members of the group. And we note that the elements of crime include systematic expulsion from homes as an example of the acts that are referenced under Article 6C, such that the systematic arrests conducted in Luz and Luzari could qualify within the provision. We say that the forcible arrests are both a material element of the crime under Article 6C, but that they also are evidence of Mr. Gravis's genocidal intent, as they impact on the group's ability to reconstitute itself. And with that, I would like to turn to the specific intent required for the crime of genocide.
Councillor, if I can just stop you there then before you move on, please. You've referred to the Castilians as an ethnic group. And in terms of the case facts, we see that Castilians can include everybody living in Castilla, and it therefore can potentially be a political group. How can you persuade the bench that actually it is an ethnic group that we're dealing with here and not merely a political group?
Your Honour, firstly, we would point to paragraph 4 of the facts, which refers to Castilians as an ethnic minority. And in particular, that's because they share their own language and religious customs. And that is in particular the way in which we are invoking the Castilian group in their ethnic capacity. We recognise that there may be other ethnic groups living within Castilla. However, our submissions are that the focus of Mr. Gravis's attacks being in Castilla was to target that specific ethnic group, and that any other victims were not the primary focus of the campaign, which I will deal with under my submissions for genocidal intent. We would say that the main political group that is elicited on the facts is the Castilian National Front, who we would submit, although comprised of other ethnic minorities, is not the primary target of the attacks. And again, I will now move to discuss that in my submissions. We note that Article 6 demands dolus specialis, that the perpetrator intended to destroy in whole or in part a national, ethnical, religious or racial group. And here we note that the jurisprudence suggests that genocidal intent can be inferred from the factual circumstances of the crime, given that it is very unlikely that an individual would express their direct intention to commit the crime of genocide. And in assessing genocidal intent, we ask the Chamber to consider whether all of the evidence, when taken together, demonstrates the genocidal mental state, rather than considering each act specifically and the intent behind that particular act. And this was confirmed by the ICTR in the Starkitch appeal judgment and also the Ptolemyer appeal judgment. In drawing an inference that Mr. Gravis's genocidal intent existed, we are again asking the pre-trial chamber to be satisfied of this on the evidentiary standard of reasonable grounds. We make several points in relation to the existence of genocidal intent. And the first is that there is that requirement of substantiality. A substantial part of the group must be targeted.
Counsel, I'm having a little trouble with the argument here. You're relying on Article 28 as the theory to connect the defendant with the genocide. Are you conceding that in addition to whatever is required under Article 28, the prosecution has to establish the dolus specialis?
Yes, Your Honour. So we are using Article 28 primarily as the vehicle to establish the acts committed, so the killings and the conditions of life inflicted, which were not personally perpetrated by Mr. Gravis, to attribute them to him as the military and political leader. However, our submission is that the relevant actor that held the genocidal intent, who was carrying out the genocidal campaign, is Mr. Gravis. To that question, we would also note that the pre-trial chamber in al-Bashir held that if an individual uses state apparatus that they are in control of to carry out a genocidal campaign, that genocidal intent can be inferred from the actors within those state apparatuses. So turning to the requirement of substantiality, this also relates to Your Honour's question regarding Kastyria as a region. And here we are using the geographical Kastyrian province as evidence that Mr. Gravis was targeting a substantial part of the Kastyrian ethnical group. And this is because there is jurisprudence to suggest that by targeting the region that is culturally significant, is densely populated by the relevant group, this can elicit the intent to target the group substantially. Here we know that the killings, blockades and arrests are all concentrated in the Kastyrian province, much like the Bosnian Muslims were targeted in Srebrenica. We can take into account the strategic considerations of targeting Kastyria specifically, mostly because after the forced resettlement in 1889, we know that Kastyrians were primarily located in the province. And therefore, as touched on by Your Honour's question, though other people may live within Kastyria, our submissions are built upon the idea that Kastyria is primarily populated by Kastyrians, that it is a culturally and historically significant region, and therefore that elicits an intent to target the ethnical group specifically. Turning to the events between March 2019 and December 2021, we suggest that there are several factors and indicia to be discussed. Firstly, we submit that there is in existence a genocidal plan or policy. We submit that the May 2019 counterterrorism orders constitute direct evidence of a genocidal plan. They are referred to as a counterterrorism campaign, but we submit that they are, in essence, a genocidal plan. We note that a plan is not a specific requirement under Article 6. However, the ad hoc tribunals have consistently held that it is very strong evidence of genocidal intent, both as an evidentiary concern, but also because it is pragmatically difficult to carry out genocide without such a plan. Here we also draw attention to the level of coordination required between the Special Presidential Guard, the National Directorate of Security and the Federal Police in carrying out these orders, these systematic arrests across a period of months and across multiple towns. We'd also note that Mr. Gravis is required to have been acting within the contextual element of the crime of genocide. And here we note that this is a requirement imported through the elements of crimes. It hasn't been considered by the ICTY and ICTR specifically because it is unique to the Rome Statute. Therefore, the only jurisprudence we have on this point is from the pre-trial chamber in the decisions on Omar al-Bashir's arrest warrants. Here, there were differing opinions amongst the chamber about how to interpret the requirement. But the majority held that it must be that for a manifest pattern of similar conduct to be present, there must be a concrete threat to the existence of the group. Here we submit that it is known that there are 286 people killed, many others arrested, 150 Kastyrian women abducted. We submit that this cannot be considered, as Their Honours held, a latent threat. It has progressed past that point. If Mr. Gravis had stopped at his March 2019 arrest and had never introduced the plan, perhaps there'd be an argument to say that the threat was indeed latent. But here we submit that the threat is well and truly concrete. Your Honours, having made submissions that there are, at the very least, reasonable grounds to conclude that the case against Mr. Gravis falls within the court's jurisdiction, I will now defer to my co-counsel to address the mode of liability and admissibility challenge.
Madam President, honourable judges, if it may please the court, I would seek to move these proceedings today away from my learned co-counsel's submissions on Article 19 and to the second matter on the agenda of this court today, that being the doctrine of command responsibility under Article 28. Specifically, Your Honours, we seek to rely on Article 28A today, as Mr. Gravis is both the Commander-in-Chief as well as the President of Honiton. He is in complete control of both the body politic as well as the security services and the militia. Your Honours, the doctrine of command responsibility is one that has been developed over nearly half a century now in both ad hoc tribunals, the Geneva Convention, as well as this very chamber. Specifically, we seek to rely on the three consummate elements that are included in the Rome Statute, those being the requirement of a sufficient relationship between the superior and the subordinate, a sufficient degree of knowledge held by the superior of their subordinate's actions, and finally, that the actionable element, as it were, that the superior has failed to act and failed to extinguish their duties to either repress or subsequently, either to prevent or subsequently to repress and subsequently punish. We submit that the critical element today for the prosecution to make out is the second element of knowledge, either in the higher standard of actual knowledge or this lower standard of constructive knowledge. And we submit this on the basis that the superior-subordinate relationship in the present case appears to be founded on the facts. That is to say that Mr. Gravis has both de jure as well as essentially de facto authority over the military forces. And we would point to paragraph 11 of the compromis as evidence of this, as we see that Mr. Gravis has given the order, the decree of the counterterrorism orders. And within 2 months, we see that there are boots on the ground from the relevant parties in the relevant region. There's no suggestion of any form of dissent, that Mr. Gravis's power has been in any way usurped. And as such, we submit that he has effective control in the present case. Now, concerning the question of knowledge, we submit that whilst it's not immediately apparent on the facts, actual knowledge can be made out in the present case. Now, I say that it's not immediately apparent on the basis that there is nowhere that says that Mr. Gravis sat in a meeting with Ms. Jolie and Mr. Bryan, the heads of two of the relevant forces, and had a conversation with them. However, the jurisprudence of this chamber has developed such that it states that actual knowledge can be found through either direct or circumstantial evidence, provided that it is the only reasonable conclusion, was the phrase that they used in the trial chamber in the prosecution of Mr. Bembagombo. Your Honours, we submit that in the present case, we can construct a timeline that demonstrates that Mr. Gravis having actual knowledge is the only reasonable conclusion. And we base this on both circumstantial and direct evidence, which is to say, evidence such as the fact that he gave the order himself, that it's well within the scope of his powers, that the order was, there is a temporal nexus between him giving the order and it being carried out of 2 months, as I've mentioned previously.
Sorry, Councillor, just to interrupt you there. You keep saying he gave the order, but from the facts, he didn't give an order for crimes to be committed. It's as your co-counsel conceded, as part of a counter-terrorism orders. So when you say he had direct knowledge because he gave the orders, can you just clarify your point there, please?
Yes, Madam President. He gave the decree for the counter-terrorism order as within his capacity as both President and Commander-in-Chief. We submit that given the context of his previous statements, this was to be taken to mean essentially commit the act. Well, we submit that given his previous statements, it was to be inferred that such acts should go ahead in these regions. Specifically, I would point the court to paragraph 10, specifically where he talks about how the Castilians and their supporters are lying rats, vowed to revenge the dead military personnel and to eradicate this Castilian cancer from the map of the country. Your Honour, I would then, as my learned co-counsel pointed to, it is the disparity in the number of Castilian of the Castilian ethnic body who are targeted that points toward the conclusion of genocide as opposed to merely a dictator run wild. Your Honours, it's when you hold the actions of Mr. Gravis and the orders that he passes down in the counterterrorism decree in conjunction with the contextual elements that we submit, it should be inferred that he intended for this outcome. Your Honours, this is to say that when you combine the proximity of the order with the carrying out of the actions and the direct evidence that we have on the facts of Mr. Gravis's knowledge, it appears logical that the only reasonable conclusion is that Mr. Gravis had actual knowledge. And I would point the court to, firstly, to Exhibit 1 of the compromise, where we see a text conversation between Mr. Gravis and Ms. Jolie. Now, specifically, this text conversation is actually fairly unremarkable, except that it places Ms. Jolie in the combat area at the time. I would note that the text conversation happened on July 16, the day after the critical search of July 15, as we see at paragraph 12 and 13 and 14. The reason why this is so important is then when it's compounded by the interview given by Mr. Bryan at paragraph 12, where he is the head of the police force, one of the bodies carrying out Mr. Gravis's counterterrorism orders, acknowledges that it is the NDS and SPG's role within the region to carry out those orders and to prevent potential threats. We submit that these words shouldn't necessarily be taken at their highest. Your Honours, because of this, we submit that there is both circumstantial evidence as well as direct evidence that suggests that Mr. Gravis commissioned these acts and that furthermore, he had knowledge of their going on. This is particularly apparent given the final order of the counterterrorism decree, which is at paragraph 11E, where he establishes that there is a reporting system in place between himself directly, as well as the 3 organizational heads, that they must report to him personally and on a regular basis. Your Honours, this enlivens the notion of the constructive knowledge as well, in the sense that either the reporting system worked and Mr. Gravis had actual knowledge, or consequently the reporting system didn't work, and we would submit that the duty to know, as it were, as was founded by the trial chamber by the pre-trial chamber in the prosecution of Mr. Bemba-Gombo, must have been enlivened, as at that juncture, Mr. Gravis has not done sufficient acts in order to extinguish that duty. We note that on the facts, there's only one instance of him seeking to obtain information, and that this would not be sufficient, particularly in light of his authority and the nature of the actions going on within the region, to extinguish this duty. Your Honours, we submit that the knowledge is a critical aspect on the basis that when we turn to the failure to prevent or repress, there is remarkably little to be said about Mr. Gravis's actions. Notably, he's done practically nothing. There's no suggestion that he sought to prevent the actions from occurring. Rather, we would submit that he commissioned them. And subsequently, there's no suggestion that he took any measures to mitigate the actions, or indeed, when they went too far, if indeed, in his perception, they did go too far, to punish the necessary actors. It's on this basis, Your Honour, that we would seek to move to the second or the final matter of these proceedings, and that is concerning the Article 17 and the doctrine of admissibility. Now, we note that our learned friends of the defence are seeking to rely on this, and whilst we don't seek to invert the burden, as it were, as they are relying on this point at first instance, of course, they do bear the onus of demonstrating to the court that there is a military or a national investigation of the relevant kind to strike out the admissibility of these proceedings before this court. And we have several submissions to be made here, Your Honours. However, given that our learned friends haven't made submissions at this juncture, it's likely that we will also seek to address these submissions in part in our rebuttal, so as to best address this court. Your Honours, concerning the military investigation, which no doubt will be the crux of my learned friend's submissions, if I could take the court to paragraph 18 of the compromise, we see that the military investigation has an extremely broad scope. And that is to say that it covers all crimes committed within the conflict region from November 2015 onwards until September 2021. This is a period of nearly 6 years. The ICC prosecution, of course, or the investigation by the prosecution, only lasts from March 2019 until September of 2021, both including when Mr. Gravis was overthrown. We would note that, of course, this means that the investigation by the prosecution is only just over 2 years and only concerns the actions of the crime of genocide, as opposed to the investigation by the military, which concerns all crimes committed within all conflict regions. Now, this means that they do overlap. However, we would point to the traditional same person, same conduct test, and that these is not substantially the same conduct as was held to be necessary in the prosecution of Mr. Muthora, Mr. Mugwai Kenyara, and Mr. Hussein Ali in the pre-trial chamber. Your Honours, the second point to make concerning the national investigation is its relative inaction. We note that it states that it will produce its findings by August 2022. However, there's no indication that the military investigation has indeed done anything. And we submit that it is incumbent upon the defence in the present case to demonstrate that the investigation is actually on foot and not merely a smokescreen of sorts. In the present case, we would make the claim that on the facts, there is no evidence.
I'm a little puzzled by your argument concerning the burden of proof in respect of admissibility. Can I draw your attention to Article 67(1)(I) of the Rome Statute, talking about the rights of the accused, and it says the accused has the right not to have imposed on him or her any reversal of the burden of proof or any onus of rebuttal. You used the word onus to describe what the defence has. How do you deal with 67(1)(I)?
Yes, Your Honours. In answering that question, Your Honours, Madam President, could I seek an additional minute or so?
Yes, please answer the question and then please finalise and wrap up your conclusion.
Yes, Your Honour. Judge Clark, we would submit that there is no issue of a reversal of the burden of proof in the present case on the basis that it's not that the prosecution has sought to raise admissibility at first instance, at which point it has been placed upon the defence. Rather, the defence seeks to rely on admissibility to strike out these proceedings. It would be wholly illogical for the defence not to then have any form of burden imposed upon them if they themselves seek to enjoy the benefit of striking out the admissibility of the proceedings. Indeed, the cases such as the case I mentioned earlier of the prosecution of Mr. Muthora imposed such a burden. Does that suffice, Your Honour?
Short of time, so please go on. Yeah.
Your Honours, in light of that, if the court has no further questions, I would seek to conclude my submissions there.
Thank you, counsel. If I can now turn to the defence to commence.
Okay,
sorry, I think I
may I
do have
interrupt,
questions.
please? Can you hear me?
Yes, please go ahead, Judge Sémien.
Yes, very, very quickly on the establishment of the military court. Just ask to the prosecution team, you don't think it's a kind it's a way for the country to show his willingness to start prosecutions? You don't think we can consider it as a point to be highlighted under the complementarity view? Because one can say that since a court was established, investigation will soon start, and maybe the jurisdiction of the court might be delayed. You don't think so, prosecution team?
Your Honour, of course, the facts are relatively lacking in regards to the existing jurisdiction or the judicial infrastructure within the state of Hanatun as it stands, as well as the judicial rigour that has been implemented over the past several years under Mr. Graf's leadership. However, we would simply make the submission that at this juncture, there is nothing to suggest that the military investigation is going forwards with any veracity, and that further, it was only ultimately founded on the basis of pressure from human rights groups. We simply submit that there is little to suggest that there is actually a willingness to prosecute, or there's little to evidence a willingness to prosecute. And there's little to evidence that the investigation itself is going ahead with any authenticity or veracity.
Okay.
Thank you, Your Honours.
Thank you. I think those are all our questions for the prosecution at this moment. If we can now turn to the defense, please.
Thank you, Madam President. May it please the court. Your Honors, even though the prosecution has deviated from the established agenda for today's hearing, for the next 15 minutes, I will be mirroring the arguments as raised by the prosecution as presented in their respective components, and I shall demonstrate that firstly, this case is not admissible under Article 17, primarily because it violates the complementarity principle. And secondly, this court lacks subject matter jurisdiction under Article 5. Cumulatively, there are no reasonable grounds to believe that the specific and contextual elements of genocide under Article 6A and C of the Rome Statute obtain in the present case. And with the permission of the court, I will now discuss how this case violates the complementarity principle. Your Honors, we accept the law as has been put by the prosecution. However, no less than the Rome Statute as underscored in the 10th preambular paragraph in Article 1 that this court would be complementary to national criminal jurisdictions. Therefore, this court is called upon to determine the following. First, whether the military court's continuing investigation satisfies the first precondition of an ongoing domestic investigation which substantially covers the same case. And second, whether the military court's investigation is vitiated by unwillingness or inability. And contrary to what the prosecution asserts, the defense contends that the military court's establishment and its continuing investigation satisfies the first precondition. And given the apparent jurisdictional conflict, this court should complement Hanaton's military court in order to fulfill its duty to exercise criminal jurisdiction at the first instance. Your Honors, as a matter of law, Article 17(1)(a) as worded makes no qualification as to the system of investigation to be employed by the domestic state. And Principle 17 of the Decode Principle recognizes that in all cases where military tribunals exist, they have the authority to rule at the first instance. And at this point, Your Honors, the defense wishes to dispel the apprehension towards military justice by invoking the case of Regina versus Genero, where the Canadian Supreme Court stressed that the Code of Service Discipline is not merely concerned with considerations of discipline and integrity. It likewise serves a public function by punishing specific conduct which threatens public order and welfare. And Your Honors, the defense understands that the military court's establishment might be seen as a reactionary to the clamor of human rights organizations. However, we submit otherwise. Professor Mindya Bakshmadse observed that the state practice in common law jurisdictions suggests that ad hoc military tribunals are convened on a case-by-case basis. And the provisions of manuals for court-martials of US, Canada, United Kingdom, among others, confirm this practice. Therefore, Your Honors, Hanaton's ad hoc military court retains its legitimacy and competency to fulfill its investigative and adjudicative functions. And at this juncture, the defense maintains, Your Honors, that both limbs of the same person, same conduct test are satisfied. In paragraph 71 and 72 of the Gaddafi admissibility judgment, the appeals chamber ruled that what constitutes the same case would be the extent of overlap in the investigations of the conduct. And while we acknowledge, Your Honors, that the case record is not explicit as to who is being investigated and for what conduct, the temporal and geographical scope of the investigations provide an inferential springboard that, with respect to the same person limb, if we read paragraph 15 alongside paragraph 6 of the case record, this only proves, Your Honors, that there is no other point person but Mr. Gavos. The military court was established to investigate the crimes in the conflict regions. And in this case, Your Honors, Mr. Gavos is the very same person that is being investigated by the military court. And with respect to the same conduct limb, if the concept of the incident refers to a historical event, which is defined in time and place where the crimes within the jurisdiction of the court were allegedly committed, then the defense submits that the incidents investigated by the military court encompasses the incidents under the present indictment. And while the OTP was established 2 years ahead of the military court, we have observed that first, the OTP's temporal scope of investigations is rather limited compared to the military court, which extends as far as 2015 and is set to conclude in August 2022. And second, the places covered by the military court is specific. At any rate, Your Honors, while we do acknowledge that admissibility determination is based on the facts, the defense submits that if this court were to declare the case admissible, such decision would be premature and procedurally flawed. In paragraphs 45 to 50 of the recent Yekatom appeal admissibility judgment, the appeals chamber tells us that when an admissibility challenge is brought by an accused on the ground that a state is or may be investigating or prosecuting the same conduct, chambers have a general duty to always invite the state concerned to submit observations. In this case, Your Honors, it would be premature to decide that this case is admissible, considering that the military court is set to conclude its investigations on August 2022. Your Honors, the Republic of Anaton should not be deprived of a meaningful opportunity to give its submissions that it is indeed investigating the case. And
sorry, Counsel, can I interrupt there?
Yes,
can you just clarify for the bench? Because your argument appears to be quite contradictory. On one hand, you're saying, well, the investigation isn't complete, it's premature, we haven't heard from the state of Hanaton, but at the same time, you, the defense, have brought this admissibility challenge, and you're declaring that the parameters of the case are indeed the same. Can you please just clarify how you marry those two seemingly inconsistent positions, please?
Your Honors, the defense understands that while it may seem to be incompatible, the defense maintains that these submissions are compatible. The defense submits, Your Honors, that given the novelty of the circumstances, it would be onerous for the accused to be subjected to the standard of proof used in state challenges. And as it stands, Your Honors, there is a considerable disparity between the state and the accused with respect to access to official records and resources. And this tells us, Your Honors, that the military court would be able to provide this court additional information come August 2022. And Your Honors, the defense likewise submits, turning now to the question of jurisdiction, the defense notes that the most contentious aspect of jurisdiction is with regard to subject matter jurisdiction. And as it stands, there are no reasonable grounds to believe that the specific and contextual elements of genocide under Articles 6A and C obtained in the present case. Our submissions in this regard are cumulative. Therefore, this court loses jurisdiction upon showing that one of the elements are not met. And Your Honors, before I contest the actus reus of genocide, perhaps it is best to inquire whether the victims belong to a protected group under the Rome Statute. And contrary to what the prosecution asserts, the defense wishes to point out that they have mischaracterized the Castilians to be targeted as an ethnic group. As can be gathered from paragraphs 7, 8, and 12 of the case record, Your Honors, Mr. Gravas is particularly opposed to the creation of the Castilian National Front, which was created to fight for the fundamental rights of the Castilians. Throughout these passages, it is apparent that the animosity between Mr. Gravas and the CNF and their supporters is rooted in political differences. Your Honors, the text of the Rome Statute and even the jurisprudence of the ad hoc tribunals affirm that political groups are not recognized groups per se. And this moves me, Your Honors, to the notion of contextual element, where the defense submits that the constitutive elements rather, and that the defense submits that there are no pieces of evidence which demonstrate that Mr. Gravas caused the alleged killings, direct or otherwise. The evidence relied by the prosecution in this regard, the IHRD reports, is problematic. And in paragraph 29 of the Bagbo decision adjourning the hearing on the confirmation of charges, the PTC stated that reliance to NGO reports is problematic precisely because the chamber itself does not know the source of the information and is deprived of vital information as to the source of the evidence. And in such cases, Your Honors, the chamber is unable to assess the trustworthiness of the source. In this case, Your Honors, the defense submits that the IHRD report in paragraphs 12 and 14 of the case record cannot be relied upon because they lack probative value. And in paragraph 521 of the Akayesu judgment, The trial chamber ruled that the killing must have been committed against one or several individuals because such individual or individuals were members of a specific group and specifically because they belonged to this group. Thus, the victim is chosen not because of his individual identity, but rather on account of his membership to a national, ethnical, or racial group. Furthermore, Your Honors, in paragraph 500 of the same case, the ICT are considered the English and the French versions of the Genocide Convention, where it ruled that the French term was to be preferred than the English term killing, as the latter could refer even to unintentional homicides. This means, Your Honors, that the killing has to be committed with intent to cause death. And in this case, Your Honors, the defense submits that Mr. Graves could not have intended to kill those who died in the series of searches in Luz and Luzari by reason of their ethnicity. In paragraph 12 of the case record, it can be gathered that those who died were shot because they resisted arrest. And turning now, Your Honors, to life conditions, as a matter of law, the first element of Article 6C requires that the act be deliberately done, meaning the perpetrator must have mens rea to inflict certain conditions of life upon one or more persons. And here, Your Honors, the defense maintains that Mr. Graves did not intend to cause the alleged famine. And according to the United Nations, a famine can be declared only when certain measures of mortality, malnutrition, and hunger are met. However, Your Honors, there is no severe famine to speak of in this case. Dr. Robert Mayer posits that blockades are justified when the aim of the operation is to put pressure on the enemy state and to weaken its fighting force and to compel it to come to terms. In this case, Your Honors, the defense submits that the blockade is justified since it is put in place to address the danger of CNF attacks. At any rate, the population in Castilla will be able to sustain themselves, considering that in paragraph 4 of the case record, most of the Castilians migrants opened businesses in the agricultural industry. Therefore, Your Honors, Mr. Graves could not have intended to deliberately induce famine to physically destroy Castilians. And turning now, Your Honors, to my last submission regarding mens rea. Dolus specialis, or specific intent, is a stringent requirement for the crime of genocide. And to qualify as genocide, discriminatory intent does not suffice. It has to be coupled with specific genocidal intent to destroy the group as such, in whole or in part. Your Honors, in the ICTY case of Prosecutor versus Berjanin, it should be noted that while the accused openly derided and denigrated Bosnian Muslims and Croats by calling them vermin, scum, infidel, and second-rate people, the trial chamber ruled in that case that while those utterances strongly suggest the accused discriminatory intent, they do not allow for the conclusion that the accused harbored the intent to destroy the Bosnian Muslims and Croats of the ARK. In this case, Your Honors, it is undisputed that Mr. Graves openly derided the Castilians by calling them lying rats, and he even vowed to eradicate this Castilian cancer from the map of the country. It is submitted nonetheless, Your Honors, that these statements were not as inflammatory as in the case of Berdanin. Such statements do not evince specific genocidal intent on the part of Mr. Graves, and if at all, it was nothing but a hyperbolic and inflammatory statement of indignation in response to the March 15, 2019 ambush. Your Honor. Yes, Your Honor.
Can I just ask you to clarify, with relation to specific intent, who is it that must hold the specific intent on the defenses in the defense's submissions?
Your Honor, the defense submits that it would be the accused in this case, Mr. Graves, who should have the requisite specific genocidal intent. However, the defense maintains, Your Honors, that that Mr. Graves did not have the specific intent to destroy the Castilians by reason of their ethnicity. Your Honors, this concludes my submissions as the first counsel for the defense. Unless I may be of further assistance, and I now yield the floor to my co-counsel to assist you on the question of criminal responsibility. Thank you.
May I interrupt? May I interrupt?
Certainly, Your Honor.
Okay. On this last point, the responsibility of Mr. Graves as a military commander. Looking at Exhibit 1, do you think that this text exchange, that this text message is enough, is sufficient for him as military commander to monitor accurately the situation and to be reported? I think don't you consider that Mr. Gravell should have taken additional measures to control the situation for him to avoid such acts to be committed on his behalf?
Your Honor, the defense submits that Exhibit 1 does not hold water in this case, as what will be elaborated by my co-counsel. Mr. Gravas could not be held criminally responsible because he did not have effective control over his subordinates. Thank you, Your Honors.
Good day, Madam President, Your Honors. May it please the Court. My name is Eric-Aimé Sémien, the second counsel for the defendant, Mr. Gravas. Turning now to the topic of command responsibility. The defense submits that there are no reasonable grounds to believe that Mr. Gravas is criminally responsible under Article 28A of the Rome Statute. Your Honors, as explained in the Bemba pretrial decision, in order for a commander to be liable under Article 28, all the legal requirements must be complied with, meaning the absence of any of these requisites is enough to prove that Mr. Gravas is not criminally liable. Contrary to the contention of the prosecution that 3 requisites were complied with in this case, that sufficient relationship, knowledge, and failure to act, on behalf of the defense, I seek to demonstrate 3 submissions. First, that Mr. Gravas did not have effective control. Second, that Mr. Gravas did not have knowledge and the should have known standard was not actually met in this case. And third, that Mr. Gravas did not fail to take all necessary and reasonable measures within his power to prevent or repress the alleged crimes. Your Honors do not have any preliminary questions. Allow me to proceed to my submissions. Thank you and may it please the Court. First, for the effective control. The defense put forth that Mr. Gravas did not have effective control. Your Honor, the defense acknowledges that Mr. Gravas was effectively acting as a military commander, and thus the standard we should look into is Article 28A of the Rome Statute. However, pursuant to Article 28 itself and to the explanation of in the Condic and Cirqued's ICTY case, the mere title, de jure or de facto, will not suffice to determine the authority of a person. There must thus be a determination of the reality of the control of such commander, and we thus need to look into effective control. As provided in paragraph 188 of the trial chamber in the Bemba case, effective control is the material ability to prevent or repress the commission of the crimes. And there are several factors that were enumerated in that case. Your Honors, paragraph 189 of the 2016 Bemba case provides that the formal position is not enough. It is just one indicia. The prosecution failed to mention that another indication of the lack of control, an indication of a lack of control is the disregard or non-compliance with the orders or instructions of the superior. The prosecution repeatedly said that Mr. Gravas ordered for the commission of the crimes. Although the power to issue orders is one indicum to determine effective control as provided in the paragraph 204 of the Halolivic ICTY case, the power to issue order is not per se would show effective control. Your Honors, in this case, it is clear that the subordinates did not follow the orders of Mr. Gravas. I would like to draw your attention to paragraph 11 of the case facts in which Mr. Gravas introduced the counterterrorism campaign. In the campaign, Mr. Gravas instructed the forces to eliminate destructive social functions and to take necessary measures against terrorists and Castilian supporters who are a threat to national security. This Mr. Gravas also provided in paragraph 11D that the said forces should determine who the terrorists are. It is thus apparent, Your Honors, that Mr. Gravas gave qualifiers for the forces to determine who the persons targeted by the campaign. But in paragraph 12 of the case facts, the forces shot Castilian men who were not identified as terrorists or supporters of terrorists. Also, pregnant women were kicked. And another instance found in paragraph 14 of the case facts would show that police shot male companions and actually forced female to provide for sexual favors, which were nowhere in the instructions of Mr. Gravas. Again, these victims were not identified as terrorists and were not branded as a threat to national security. In this case, the disregard of the forces of the said instructions of Mr. Gravas is indicative of the lack of effective control of Mr. Gravas. Your Honors, it is also of the position of the defense that Mr. Gravas did not effectively manage the forces. We would like to echo the separate opinion of Judge Van den Wingeert and Judge Morrison in the Bemba appeal case, that it is simply impossible for senior commanders to control hundreds or thousands of troops effectively, because that is actually the role of those who are closely working with the forces, which are the immediate commanders, and in this case, the heads of the securities. Mr. Gravas was far too removed from the chain of command. With this, the defense was respectfully submits that Mr. Gravas did not have effective control. The defense has proven that the element of effective control was not present in this case. And thus, but nevertheless, we would like to proceed with answering the prosecution's submissions with regard to knowledge and with regard to the capacity of Mr. Gravas or his failure to repress the alleged crimes. Your Honors, for our second submission, we put forth that Mr. Gravas did not have actual knowledge and that the should have known standard was not met. The prosecution is off the point that Mr. Gravas had ordered, and actually the said prosecution said, and we agree with it, that actual knowledge can be established through direct or circumstantial evidence. But actual knowledge cannot be presumed, as provided in the ICTY Halodovic case. With regard to the contentions of the prosecution that Mr. Gravas ordered, and that the only reasonable conclusion that can be inferred from Mr. Gravas' statements that the said Castilians were lying rats was that Mr. Gravas had actual knowledge. However, Your Honors, they were implementing an anti-terrorism campaign, Mr. Gravas, and it cannot be avoided that there is some amount of force to quell terrorism, for which the UNSC itself allowed states to take necessary steps to prevent terrorism. But Your Honors, when Mr. Gravas used the word to destroy, it does not necessarily mean that they should physically destroy or do whatever they wish to do. As in the case of Karadzic, prosecutor versus Karadzic, the orders should be taken into context, and the parameters of Mr. Gravas given must be taken into consideration. Mr. Gravas was clear also with the goal of preserving national peace. The killings, the sexual harassments, this were not part of it. And also, now taking into consideration the other circumstantial evidence, we would also like to say that, yes, we agree with the prosecution that circumstantial evidence, such as Mr. Gravas did not order the said commissions of the crime, and he was not actually informed personally, as when Ms. Jolie, the head of the security, reported to him as provided in Exhibit 1, the said report was not, it was a general situation in Castiria. And Ms. Jolie actually assured Mr. Gravas that everything was under control in Castiria. This shows that the actual knowledge is not the only reasonable conclusion from this. As to the should have known standard, we put forth that even though there was a hierarchical communication system, this is not the only indication that he could have had knowledge, as provided in the Blastic appeal case ITTY. And we also would like to put forth that Mr. Gravas had actually asked Ms. Jolie in Exhibit 1 for information on what was happening in Castiria. I would also like to point out that in the separate opinion of Judge Van den Wingeert and Judge Morrison in the Bemba appeal case, if a commander has a genuine reason to doubt the accuracy of the source of information, then this may absolve him of the knowledge requirement under command responsibility. With that, going on to our third submission, the defense put forth that Mr. Gravas did not fail to take all necessary and reasonable measures.
Counsel, can I just interrupt you there, please, in respect to should have known? We heard from the prosecution that in context and giving the order that all necessary measures should be taken to stop as part of the counterterrorism. And in the context of Mr. Gravas's media statements and the historical issues in Castelia and within Hannington, that he should have known that there was potential for crimes being committed. As I understood it, that was the prosecution's argument. Can you just please respond on that particular point on should have known, within the context of things setting up before? Thank you.
Yes, Your Honor. Your Honor, I see that my time is almost up. Can I just answer this question and conclude? Yes, Your Honor. With regard to the acts of Mr. Gavos when he went into media, Mr. Gavos also clarified this into media that his statements were being was being twisted by the media. And with that also, there is actually reason in this case for Mr. Gavos to doubt the accuracy of information, because Mr. Bryan, the head of the police, actually denied some of the information which are against the IHRD claims. And with this doubt in mind, Mr. Gavos could not have had known that such criminal actions were being committed in Castelia. With that, since these elements were not met under Article 28, then Mr. Gavos there are no reasonable grounds to believe that Mr. Gavos is liable under Article 28 of the Rome Statute. And unless I may be of any service or questions, this concludes the submissions of the defense. May it please the court.
Unless there are any further questions, I think we can move to rebuttal if the prosecution has any. You have 5 minutes.
Thank you, Madam President. We would seek to use our rebuttal, and we have several points to make in respects to each of the grounds. I would begin with Article 17 and move through 19 and 28 in turn. The first point to make concerning Article 17 is the submission that my learned friend made concerning the investigative step that the military investigation represents. Specifically, my learned friend stated that the finding of the military court itself is sufficient to demonstrate that there is a willingness and that is an investigative step that is sufficient for the purposes of Article 17 admissibility. However, we would direct the court to the jurisprudence of this court in the prosecution of Mr. Muthara, Mr. Mugwai Kenyatta, and Mr. Hussein Ali, where it was stated at paragraph 40 that an investigation requires the taking of steps directed at ascertaining whether this individual is responsible for that conduct, and that the court stated that this may include interviewing witnesses or suspects, collecting documentary evidence, or carrying out forensic analyses. The point to be made here, Your Honours, is that there's nothing on the facts to suggest that anything has actually happened. The finding of the military court of its own accord might be sufficient to set aside inaction, but it doesn't necessarily set aside unwillingness on behalf of the state to actually prosecute Mr. Gavos. Your Honour, I would then take the court to Article 19, where my learned friend on the defence stated that the IHRD evidence, the interview, shouldn't be considered admissible before this court on the basis that the IHRD is an NGO. We would direct the court to Article 69, subsection 4 of this statute, which concerns the court's capacity to admit evidence. Specifically, Article 69, subsection 4 provides that the court has a broad discretion to rule on the relevance and admissibility of any evidence, taking into account, amongst other things, its probative value. Your Honour, I would also point to Rule 104 of the ICC's Rules on Procedure and Evidence, which states that the court can use NGO evidence in asserting or in assessing whether or not to open an investigation. The point to be made here is that the court firstly has the discretion, but there's no apparent bar on admitting the evidence on the basis that it is from an NGO. Your Honours, the final points to be made here concern Article 28. Now, my learned friends firstly have submitted that there is no effective control on behalf of Mr. Gavos, and that we need to look to the material ability of the leader to prevent or repress. And we would concur with the trial chamber of the prosecution of Mr. Bemba at paragraph 180. Specifically, we would submit that the question that was essentially asked in that instance was whether the leader has the capacity to prevent or repress these actions from occurring. We would submit that in the present case, there's nothing on the facts to suggest that Mr. Gavos's power has been usurped. Now, I know that there was some contention about whether Mr. Gavos was providing orders or whether it was a decree or whether it was a policy position of his administration, as it were. we would submit that the wording of paragraph 11 states that the campaign included the following orders. Now, we submit that this is in the context of a military enterprise, a military organization, and that as he is ultimately the apex within that organization, these are orders and that they flow down to his subordinates. Now, we say this on the basis that these orders are then followed. Now, Madam President, you referenced the contextual aspect of it that we discussed earlier as to how this would likely enliven a heightened responsibility for Mr. Gravis to take additional measures to find out information. And we submit that this is precisely the crux of our submission, that there is a cultural nexus, essentially, that means that Mr. Gravis ought to do more in the present case. This is the final point to be made here, Your Honours, is concerning the should have known test. My learned friend relied upon the ICTY judgment in Blaskic, which, whilst provides perhaps a method of interpretation under Article 21(1) of the Rome Statute, isn't necessarily binding upon this court, particularly when considered in light of the fact that the pretrial chamber in Bemba provided a clarification on the standard, as the standard differs between had reason to know in Article 7.3 of the ICTY statute and the should have known in Article 28(1) of the ICC statute, and these are fundamentally different. If the court has no questions on the submissions I have just made or any others today, I would seek to conclude my submissions there.
Thank you, counsel. I think there are no further questions from the bench. If we can now move to the defence, if you have any rebuttal, you have 5 minutes, please.
Your Honours, at the outset, the defence wishes to highlight the inconsistencies in fact and in law that the prosecution would have this court to believe. First, they claim that following Article 17, the military court's establishment is insufficient to sustain the finding of inadmissibility. However, Your Honours, the prosecution has failed to consider that Article 17(1)(a) as worded makes no qualification as to the system of investigation to be employed by the domestic state. And Your Honours, if you read in conjunction Article 17, paragraph 1, Article 1, and several paragraphs of the preamble, it states, Your Honour, that this court is complementary to national criminal jurisdiction. And this goes to say, Your Honours, that complementarity is the very cornerstone of the Rome Statute. Therefore, Your Honours, it would be premature to rule that this case is admissible, considering that the military court is set to conclude its investigation on August 2022. And second, Your Honours, the prosecution claimed that the IHRD report is admissible. However, Your Honours, the prosecution ought to be reminded that we do not contest in these proceedings the admissibility of the report. What we contest here is its probative value. In the jurisprudence that I have just cited, it states, Your Honours, that NGO reports have no probative value because the chamber would not be in a position to assess the veracity of the information contained therein. Next, Your Honours, the prosecution likewise conceded that CNF included groups other than Castilians. However, Your Honours, as clarified in clarification number 1, Castilians referred to both the ethnic minority group as well as the general population of people living in Castilla. This means, Your Honours, that the targeted group is not the Castilians as an ethnic group. Rather, they refer to the general population of the people living in Castilla, and by extension, they refer to the political group that is being targeted by Mr. Gravis pursuant to his counterterrorism policy. And next, Your Honour, the defense is also prepared to argue that Mr. Gravis cannot be said to have actual knowledge because Mr. Gravis' knowledge is inferred from the counterterrorism campaign orders, and that their assertions in this regard are not substantiated. Your Honours, this concludes the rebuttal of the respondent, and we thank you for your time and indulgence. May it please the court.
Thank you. The judges will now adjourn, we'll deliberate, and then we'll come back and announce the winning team. Thank you. Thank you for waiting. I think, bench clerk, are we all back now?
Seems so, yes.
Great, thank you very much. From the outset then, I think on behalf of the bench and myself, I want to congratulate you all. You all did a tremendous job in your submissions and your presentation, and in particular, your advocacy, your pace, the way you dealt with our questions, and you were unflappable in your responses and you defended them so well. So truly, truly outstanding work with your presentation. And in terms of the facts and research, you clearly had all done your jobs. And it was, I mean, we took our time to deliberate because it was very, very close. And it really came down to the rebuttals. And I want to say you both did, again, a tremendous job. For the prosecution, I think you really identified which points you needed to hit on, and you did so really well. It was very strong, the rebuttal. And then for the defense, I think you were able to really clarify points that we hadn't questioned you on, but certainly were outstanding clarifications, and you dealt with that neatly at the end there. But for us, ultimately, on the strength of the rebuttal at the end, and again, very close, but the winning team is the prosecution. So congratulations to the prosecution. And in terms of the defense, the best speaker was the first defense speaker, Mr. Magnay. So congratulations on your presentation, and good luck with the continuing competition and in your professional careers going forward. Thank you.
Thank you very much, and thank you for taking the time as well.
Thank you.
I think we can adjourn now, bench clerk.
International Criminal Court is now adjourned, and also congratulations to all participants here.